Hi, this is Billie Tarascio with the Modern Divorced podcast, and today I am joined by Tim Hintze, who is a local criminal law attorney. And we at Modern Law, criminal law comes up a lot. People get accused of domestic violence a lot, and we have sent quite a few clients over to Tim, and he has done a fantastic job for them. And today's topic is going to be talking about defending yourself when you've been accused of domestic violence in family court and in order protection. So, Tim, thank you so much for being here.
Thank you, Billy. Yeah, so I'm a local criminal defense attorney. We work hand in hand a lot, actually. Fortunately or unfortunately, however you want to look at it. There's just so much overlap in family law with the emotions and everything going. And a lot of times what we see is what triggers a divorce or a separation is going to be some sort of allegations of impropriety, domestic violence, or something like that. And you have to be careful because there's a criminal aspect there. It's not just, the emotional and the financial side of a divorce. So that's kind of where I step in there. I handle everything from misdemeanor offenses, a lot of domestic violence stuff in the family law realm, a ton of order of protection hearings, but also felony matters where there are very serious consequences to some of the allegations that are thrown around in a family law case. So kind of do it all when it comes to criminal defense. And there's a lot of overlap where Billy, we get to work together on these types of cases.
Yeah, absolutely. And I reached out to you. There were a couple a couple of situations that have come up recently that I wanted to talk to you about. The first one is, we've got. I want to say this in a very broad way. So I'm going to take my client situation and make it a little different. But we've got a client who was falsely accused of sexually molesting his 2.5-year-old. And we know that this is totally bogus. Like, the allegations are not going to stand up. But based on the pattern of the parties, she's used this as, she's done it. She's made this allegation, and she's also gotten an order of protection. So at this point, and she got an emergency order for custody. So what that means is we've got a custody hearing coming up. We have to decide whether or not to contest the order of protection. And he was invited. Well, he was going to be interviewed by the police. Now, we said, of course, don't talk to the police without talking to a criminal law attorney. And the criminal law attorney said, you can't go on the stand. You can't defend yourself in family court. You can't defend yourself at an order of protection. So talk to me about the overlap of these jurisdictions and what we can do.
Right. So unfortunately, that happens a lot. And you're balancing your interests here. So on one side, you're going through a divorce and there's children involved and there's the separation there. And on the other side, you don't want to have criminal liability on this. And the unfortunate part is for people like that, where they're completely innocent. And you look at the evidence, maybe, the police have done an investigation or they're beginning an investigation, and you just want to scream that this is insane. Like, why is this happening to this person? But you'd be surprised how many people are wrongfully accused of things. Mm-hmm. And the problem is when you have this hearing, and I get it, there's this instant, when someone files an order of protection against you, there's this instant I want to fight it. Mm-hmm. And I don't want these false allegations to be out there. The unfortunate part that you're in is there could be much worse consequences if you say something in that hearing that is incriminating. And it could be something pretty minute. And I always explain, I went to the grocery store last week, right? And if I'm getting interrogated by an officer or I'm being questioned on the stand in an order of protection hearing, and I say, yeah, I went to Safeway, last week. And they go, okay, you went to Safeway. What time did you go there? It was 7 p.m. What day? Friday. Okay. Turns out I went to Fry's at 7 p.m. on Friday, right? Shoot, they're both equal distance from my house. And I go to the grocery store. I forgot it was Fry's or Safeway. Well, now I'm a liar, right? Because I just told them I went to Safeway, but they have me on video going to Fry's. And so in a much bigger scenario, where you have a lot more involved, is something like this, and you have this molestation accusation. And if you get on the stand there and you say something that triggers, okay, this guy didn't tell the truth, that could be used against you in a criminal prosecution. And so you have to really kind of hit the pause button when you see this and you say, okay, there's an order of protection out here that's been filed against me, and these accusations are completely baseless, and they're horrible accusations. You have to slow down the urge to just run into court and scream, I didn't do this, right? Because there's potential that that plaintiff on the other side of the order of protection is represented by an attorney, right? There
Mhm.
may be an attorney that's representing them as a victim, or the victim's attorney that's there, that want to get some information from you. And the other side is everything is recorded in these order of protection hearings. It has to be recorded. If it's not recorded on appeal, they have to redo the hearing
Mhm.
if it wasn't recorded. And so if you get in there and now you say something that has incriminated yourself, that can spark a criminal investigation, where there may have been something where the police before the order of protection hearing were saying there's really not a whole lot here. And you're right. I would not recommend that a person in that situation talk to the police, especially not alone.
Mhm.
They definitely want a criminal defense attorney there. And so if you have a situation like that, you want to be prepared for, let's slow down. Let's not jump in and start testifying under oath. Let's get our feet underneath us and really figure out. So that's sometimes the hardest decision, is not doing anything with the order of protection, protecting yourself for criminal liability.
Yeah, and I mean, we certainly are balancing competing interests because sometimes the police investigation can last a long time. And
Right.
and something might not be closed. And if you can't see your child during that period of time, we are weighing pros and cons. So if someone decides they're going to testify, you've already identified one thing they need to look out for. The details have to be correct. But what else do they need to be careful of if they decide they're going to do it, they're going to testify? And also, if you're in family court, you might not have that same option. So for an order of protection, you get to decide whether or not to request a hearing to contest the order of protection after you've been served. But in family court, you're going to be served with an order to appear for a temporary orders hearing, and you have to show up.
Right.
So you can take the Fifth Amendment, which we can talk about in a minute. But so if somebody is going to testify, what can they do?
Right. So, and talking about the Fifth Amendment, yes, sometimes that's your best scenario, right? Unfortunately, that you can't say anything because you don't want criminal liability coming through. But if you're coming down there, and this is something a little bit different. Sometimes in let's say an order of protection hearing, there's a way that whatever the allegation was, that there was a third party witness to that allegation. If you can bring in a third party witness to testify that either you weren't there on that date and time, that you were with them golfing, that's great. So you can get someone else to get on the stand and deny it for you and say, no, I was with him the entire time. And that's not what happened, because he was golfing with me. He was not at that home. He was not at that apartment, whatever it was. Or if they were there and they say, that's not really how it happened. If it was a domestic violence situation where you have another witness at the house and says, no, that clearly did not happen, and here's why. I was there, I saw it. She was yelling, he was yelling, and that's it. There was no physical, this or that. And so that may be a way to get through that, is to say, I'm not even going to go on the stand, but we are going to contest this with other evidence. If there has been a police report that says that, nope, we investigated this and we did not find substantial evidence to forward this to a prosecutor to prosecute it, or you bring in another witness. Now, the absolute, in my opinion, the last thing is, all right, we put you on the stand, especially in an order of protection. Now, the plaintiff has the burden of proof there.
Mhm.
So if this is something completely baseless and you can refute that without even taking the stand, great. But if you are going to take the stand, you have to have a specific plan on questions that you can answer and questions that you cannot answer. And that's going to be a case by case determination. And really, it's, you blame it on the lawyer, right? Under
Mhm.
the advice of my attorney, I'm going to invoke my Fifth Amendment right. I'm not going to answer that question. But that may allow you to answer certain questions, denying the accusations, and potentially, work in your favor there. And especially because it may be a case where the plaintiff is the accuser or alleged victim. And now in a criminal prosecution, under the Victims' Bill of Rights, the defense attorney, the defendant, you're not able to interview that victim unless they consent to it. And so sometimes on the criminal side, we use that as a tool, and we
Mhm.
say, you know what, we're going to do this here. And we're going to walk in there and we get an interview with the victim, which is invaluable sometimes.
Mhm.
And that victim may slip up and say some things, and the truth comes out that this did not happen. But it's really case specific, because you don't want to just do a blanket. If this is the kind of accusation, then you want to testify. If this is the kind of accusation, then you don't want to testify. Because you're going to look at it and say, what are the accusations? What are the dates? And what do we have here? And when you get that global universe, then you can make the case specific decision of, we're not going in that courtroom. We're not talking about it, or we're not going to have you testify on that. Or when you testify, if you are required to testify, these are the subjects that you will invoke your Fifth Amendment right on. And a lot of people, when they look at it, they go, oh, well, you must be guilty then.
Right.
No, it's your Fifth Amendment right. Whether you're guilty, innocent, or in between, you can invoke that right, and it can't be used against you.
Okay, so let's take a step back. What is the Fifth Amendment right, and how does one invoke it?
I'm invoking my Fifth Amendment right not to incriminate myself. No person shall be made to be a witness against themselves, right? The other thing about this is when you do that, like I said, people think, oh, they must be guilty. And I get a lot of people that come in with an order of protection against them. They're the defendant, and they say, this looks really bad. I didn't do this. I think I need to fight this.
Mhm.
And we say, all right, slow down. And we make it, peel back the layers a little bit and say, we may not want to go in there and fight this for X, Y, and Z, right? If you don't request a hearing, that is not an admission of guilt in the criminal court system. Far from it. It's not a conviction. It's really nothing. You'll get a little bit of hassle at the border that there's an order of protection against you if you're traveling out of the country. But in a lot of cases, you have 1 year for that order of protection, right? Unless they want to try to extend that, which I've had happen before in serious cases where the 1 year goes, and we've advised our client, we are not going to discuss anything about this incident, and we're not going to challenge the order of protection. Once we're able to put a lid on the criminal investigation and stop that, and then the petitioner, the plaintiff on the order of protection says, we're going to renew this for a year.
Mhm.
And we go in there and say, all right, we're fighting it now, because now we know we've got the criminal investigation wrapped up in a bow, with as much certainty as you can have. And the person hasn't had contact, and they don't want this popping up on background checks anymore,
Mhm. Yeah. So, how often do you see um, what someone says at an order of protection hearing or in family court lead to criminal charges?
So that's a tough one to put like a number on. I have seen it happen before. And the other part is sometimes this just triggers something. Just today, I had a request for an order of protection hearing that I did back in, months back, that said, hey, we need the recording from that order of protection that you did for our client, because the defendant made some statements that are going to be used against them in a civil action,
Mm.
right? And so it could be civil, could be criminal. There's when you have these order of protections, there could be a wide range of pitfalls here. So they can come back to bite you, especially in a case where you have a very serious felony allegation, let's say sexual assault or something like that.
Mhm.
And the defendant, who is the suspect in the criminal case, and the defendant on the order of protection, invokes the right to remain silent and does not talk to the police. If it's a serious enough case and the police see that there was an order of protection, they may get that recording and
Mhm.
say, listen, we've got the guy on video, through a court recording, admitting to it, or, filling in the blanks that we needed to further this investigation and submit charges to the prosecutor's office. And it's hard to quantify, but the more serious the case, the higher the possibility that could happen.
Yeah, it sounds like when weighing the pros and cons, the danger of slipping up and saying you went to Safeway instead of Fry's probably isn't a massive danger. But if you're talking about an event that happened that could lead to criminal charges, you really need to talk to your lawyers and really consider carefully what your options are. Now, in family court, you may not have the ability to opt out of testifying.
Right.
And so when that happens, and you're asked about an incident, if it's the hypothetical that I first gave you, where somebody's, you know, it's been alleged that you've sexually abused your 2.5-year-old and it simply never happened, then it's pretty easy to say that didn't happen.
Right.
That didn't happen. If there's a more complicated incident, which happens all the time in family court, for instance, there was a moving day when somebody was moving out and hit somebody else with a box, and it wasn't hard and there was no injury, but they got an order of protection. And technically that's assault, right? You could be charged with assault.
Right.
So then you got to really decide, like, am I going to describe this event? Am I going to admit an act that is actually assault, which could lead me to criminal charges, or do I just let the house go? Because in that case, people can use order of protections to evict a spouse or partner from a house.
Right. So this is the scenario where you're really looking at the criminal statutes and you go, is there an intent in this statute? Did they intentionally inflict an injury on them? And then you may say, let's go in there. And no one's going to be able to make you say, I intended to hit, them with that box, right? So you can be pretty confident there to go in there and say, a box fell while we were moving and it hit, him, it hit her, whoever, and it was not intentional. I did not knowingly, that was not my intent to injure this person. I did not want to provoke them when the box fell. This was purely an accident, right? The other thing that comes to mind in like domestic violence type of order protections, where you have the plaintiff and they say, hey, he assaulted me and I have bruises on my wrist, let's say, right? To prove this assault. And they go in there in front of a judge, they get an order of protection and they show, photographs of these bruises. And the defendant, gets served with this order of protection. And you go, they're saying that that you assaulted them and they have bruises all over their wrist. And that person may say, okay, well, here's the other side of the story. They were striking me with their fists and I grabbed their wrist to stop them. And that's where the bruises came from. If you just let that lie, and someone would look at that and say, hey, he might have assaulted that person, because they have the bruises. But that would be one where you would probably say, let's go in there and testify, and you don't need to invoke the Fifth Amendment on that. You can say, here's what actually happened. I was preventing her from striking. Here's the bruise that I received, right? Mm-hmm. And the biggest thing that it comes down to on these types of hearings is it turns into a he said, she said type scenario, right? Because our burden of proof is a preponderance of evidence, which in my world, when I'm dealing with criminal charges, we're, proof beyond a reasonable doubt. The preponderance of the evidence, it's if you have 50-50, if someone hits 51%, mm-hmm. there you go. It's more likely than not that that's what happened. And so when you have a he said, she said scenario, the judge is sitting there going, what's going to tip the scales for? And it turns into a credibility thing. And so if we can show that this person only gave you half of the story, judge, here's the second half, then that tilts the scales definitely in your favor, because you can say that person's no longer credible. We shouldn't believe anything that they said. But yeah, it's a case by case scenario. In something like that, there could be a scenario where there's overlap here. Now, the orders of protection, the judge will go back up to a year, right? For whatever the act of domestic violence was. And they could go back further than that if there's good cause, but that's relatively rare. So if there was a situation where an event happened 6 months ago and someone gets an order of protection against you, 6 months later, that order of protection is going to go for the next year, right? Mm-hmm. Well, your statute of limitations on a misdemeanor is going to be a year in Arizona. So if there's something where you're kind of worried about it, maybe that statute of limitation runs, and at 6 months, you go in there and you fight that order of protection. Mm-hmm. And again, you're in the unfortunate scenario where you're like, I'm innocent of this. I did not do it, but what is this worth to me? Do I want to be battling a criminal case at the same time as the order of protection just because I didn't like that allegation was out there?
They're great points, and it just shows me Like, it's just more complicated than a blanket rule of you should never testify or you can't testify to defend yourself in order of protection. Like, that's not the rule. The rule
Right.
is it's complicated and you
Right.
need to talk to a criminal attorney and a family law attorney to balance these issues. Now, the other thing I want to talk to you about, the other hypothetical I want to talk to you about that happens a lot. So there's another case where there was an incident caught on a Ring camera where a father was rough with a child. And that happened, we're talking 12-year-old and a dad, and probably, I mean, not dad's finest moment, but this is not an abusive dad. This is a loving father with a normal, good relationship with their child. But he was rough. And mom, when she decided to file for divorce, took this 18-month-old, or it must not have been that old. Oh yeah, I think it was 18-month-old video to the police. He got charged with child abuse. He pled guilty. Then eventually he pled guilty. So he's got a child abuse conviction, and I think it came with diversion. So,
Okay.
so he's thinking, his criminal law attorney is telling him, like, this is the way to go. Well, now we're in family court, and this man has been convicted of child abuse. And even though we have a good, loving father with a long track record of having a good relationship with his children, and his wife, of course, encouraged that and left him alone with the kids for a long time, now we've got a divorce. And now the wife is saying, of course, that he's abusive and should have supervised visitation only. Talk to me about that situation and what we can be doing.
Right. So that's a tough one, because what you have the criminal case going, you said maybe 18 months ago, the child abuse is probably something like a class 4 felony, that he was charged with there. And if he was convicted of that, then, and correct me if I'm wrong here, once you get to the family law side, you have this presumption, if there was domestic violence there, that he should not be with the children or that child, right?
That the parent should not have joint legal decision making unless you overcome that presumption. And any parenting time has to create protections for the child and the other parent. So it can really be problematic in family court.
Right. And so there's a couple different ways to handle that. One, if you're in that criminal case, you're fighting tooth and nail. If you have the hindsight to see that this is going to come up later, and I'm not going to be able to, be with my child when I want to be with my child, right? You're fighting that tooth and nail. It's difficult when you have, camera footage, and you really have to make that. It's a game time decision there. Hey, is this something that we can fight and we can win? If we can be successful on this, we're never going to be able to give you, 100%, probability or something like that. But you really have to take that into consideration, even with like you said, if there's something like diversion, which for people that don't know, you're charged with a crime, and then you and the prosecutor, maybe the victim, you work out something that says you are going to pay some fines, you're going to pay some restitution to the victim, then you're going to do some classes, some community service, and in exchange for that, we will dismiss the case.
Mm-hmm.
Well, some prosecuting agencies, they do what we call a post-plea diversion program. So you plead guilty. Let's say you pled guilty to a domestic violence offense, and then the judge suspends entry of the sentence, and then you complete your community service, you do your classes, you pay your restitution. As long as you do that within a certain amount of time, then the case gets dismissed. The problem is when you have a different court that's deciding family law matters, and you had to make an admission that you were guilty to domestic violence or whatever, child abuse, whatever it may be. And that will really hurt in a family law matter. So, there's the ways to go about it is you're going to fight that criminal case, tooth and nail. But if you're already in the situation where they did diversion on this, depending on your judge, when you get in there, hey, this is how long ago that was, right? This was 18 months ago. This was a lapse in judgment. Because now, remember, at this point, you're not worried about the criminal investigation, right?
Right.
That's already done. And so you can kind of clear your chest, clear your mind, and say, here were the things that were going through my mind at that time. Here's what I was struggling with, and here's how I've overcome that. You can see in the X amount of years that I've been a father or a mother, that there has not been another scenario like this. And the unfortunate part is if that spouse or that significant other, like you said, they didn't have any problem with this person being a parent for the last 18 months, right? And it turns into a bit of a vindictive kind of thing. And what we need to remind people sometimes is that the court is not all about punishing people. There's a side of it that's supposed to be the criminal court. There's the side of it that's supposed to be about rehabilitating. And so just because someone has done diversion or they've had, a criminal offense, a conviction in the past, doesn't mean that that should stick with them forever, especially if it's something that is an extreme outlier. But it's tough when the other side can go in and say, we have a conviction. He went into court and he admitted that he did this. So it's not beneficial to go into the court and say, I didn't do that, right? In the family law court. What the judge is not looking for is for you to minimize it. It's to say, I understand the seriousness of this. What's done is done on the criminal case. Part of that could be, it was something that I really considered fighting this, but that would have involved putting my child on the stand if it's a child that's of age to testify as the victim. That would involve putting my other children, my ex, on the stand to testify about this and drag this out. So I made a personal decision to say, I will take responsibility for this and I'll do diversion, knowing that it was going to be dismissed off my record. It's not saying I didn't do it, but I didn't want to drag this out. I thought that maybe it was overcharged. It was a bit unfair, but the prosecutor saw that as well and took this down to a diversion agreement where it's dismissed off my record. I took my licks. I did what everyone asked of me. But it's tough when, the other side can come in and say, yeah, no, he admitted. He said I'm guilty in a court.
Absolutely. There's a couple things that I think are really important here. Number one is the timing of your criminal plea and your family court case. If you can figure out a way to get an agreement in the family case before you take a plea, that would be an excellent thing. If it's a lot, if you are finding yourself in family court long after you've pled, then the thing is, it's a presumption, and you have to take affirmative steps to build your case and build your story. People love to see you admit that you had things to learn, that it was not your finest moment, that you've taken parenting classes, that you've invested in yourself to do a better job. Like, that is a really good story. That's a really good way to overcome the presumption that somehow you're a danger to your children, or that you're still a danger to your children. Because the thing is, if you've been convicted of child abuse and you've admitted to it, at one point you were a danger to your children. And the only thing that you can do is say, I'm human. I made a mistake. Here's the steps that I've taken to get beyond that. And the other thing that you have to remember is that you must be patient, because it takes a while for the court to figure this stuff out. And sometimes time without your children can feel like an eternity, but taking the time to get it right, to not rush through the process, to make sure that you know what your strategy is and to execute that strategy well, will end up saving you so much time and money and heartache in the long run.
Right. Yeah. That's the toughest part that I see with people is when they come in and their family is broken apart, and their children are away from them, and they want so badly just to go in and say, let me just get this over with. Even if they say, I did it, they just want to run in and say, I did it. How do we get beyond this? How do we move past it? But the unfortunate part is, with my side of the law in criminal defense, sometimes that's not the best thing to do, right? If you have, like you said, a good person that made one mistake there, with mandatory sentencing statutes in Arizona, you don't get that. You don't get to say, I'm a good person, I just made one mistake, right? If you get convicted of that, the judge's hands are tied, and the judge says, well, you sound like a great person, but here's as low as I can go if we're talking about a serious offense, that involves prison time or jail time or something like that. And so those are the tough parts to, like I said at the beginning, to slow down, press the brakes, and you have to say, I get it, your family's kind of torn apart right now and you can't see your children, but we need to make a game plan. And it's rarely just me saying, all right, here's what I think you should do for the criminal case. Because I know what's absolute, if we could put the cherry on top for the criminal case, we took that cherry off, we may be able to move mountains on the family law case, right? So we make a little concession here in the criminal case. And then when we hand that ball off to your family law attorney, they're going to be able to do great things with that. So it's really working hand in hand to figure out what's the best route here globally, right? Because you could go in, for the family law, and let's say we're working a case together, and you say, hey, Tim, here's what we were able to do for our guy. This. We went into the order of protection. We got it taken care of. We did all this. And then it lands on my desk. And then the police charged it, right? And we go, oh, yeah, we shouldn't have done this little piece, right? And vice versa. In the criminal case, I go, hey, I got them this great diversion offer. It's getting dismissed. We're good to go. And you go, was that a post-plea diversion? What was the plea for? We should have wrapped things up in the family law court. So
Right. Like, could
that,
we plead to disorderly conduct and said, like, can we get around the child abuse? Absolutely. Like, there's a lot of collaboration, a lot of thinking, and it's complicated and it's tough, and you need people who know what they're doing. And if your lawyers aren't talking to you about these things, you need to get a second opinion.
right. 100%. Yeah, there's a lot of unknowns here, when you're going into this. And I'll be the first one to say when family law issues come up, I say, well, you got to talk to Billy, right? Because I can get you through the criminal side, but I would be doing a disservice to you if I said, yeah, I'll do your taxes for you. I'm
Right.
not that guy, right? I'm not going to do your root canal. I do, the law, the criminal defense. I can do that side, but it's really collaborative on that side because you have just so many moving parts here. And when you're talking about the emotional, physical harm of tearing a family apart, whether that's you can't see your children anymore because your parenting rights are taken away, or you can't see your children anymore because you're in jail.
Right. Absolutely. Well, Tim, we are out of time, but this has been fantastic. And I really, really appreciate all of the information. Now, how can people find you if they need you?
Right. So my name's Tim Hintze. It's Hintze. If you Google me, I pull up everywhere. But I'm a criminal defense attorney at the Rosenstein Law Group. If you go online, you can email us. My email address is pretty easy. It's actually my first name, Tim, and it's at Rosenstein Law Group. Or you can call our office 480-248-7666. But if you run into a problem like this, if you're working with a family law attorney, if you're working, Billy, if they're working with you, and you're coming across these issues, even if it's something as quick as we're just not sure, right? Maybe he doesn't need to hire me, or she doesn't need to hire me, but let's just get on the phone, and it may take 3 minutes for me to say, you're good, go ahead and do that. Or, hey, let's really come in and think about this before we go there. But always more than happy to answer those types of questions. And I appreciate you bringing me on for this to do this.
Yeah, that would be great. I can already tell we need to talk about CPS too, and what you can and can't say to CPS, but we'll have to do that another time, and we'll
Definitely.
definitely bring you on and also talk about the new changes with marijuana and
Right.
how that might impact DUIs. So we'll schedule that out. Thank you so much, and I'll make sure to put your contact information here in the show notes.
Perfect. Thanks, Billy.
Bye.